My name's Leona Powell. I'm a barrister at Blackstone Chambers, and I specialise in commercial law, and I have a particular specialism in commercial fraud. And I thought I'd address this talk today by telling you my top 3 reasons for wanting to be a commercial barrister, followed by a health warning. Top reason number 1 is that the work is genuinely interesting, stimulating, and intellectually challenging. And it's also pretty varied. And I thought the best way to illustrate that would be to tell you about what I've been doing over just this last week. So on Monday and Tuesday of the week just gone, I was in Chambers doing some pretty heavy drafting on 2 big commercial disputes that I'm dealing with at the moment. The first is for a hedge fund that's based in the Isle of Man that invested some 40 million euros into properties in the Baltic states during 2007 and 2008. And it's now suing its investment advisor and investment manager in relation to negligent advice that we say it gave during that period. I'm also acting for a big bank who made a $50 million loan to a Kuwaiti company a few years ago. And the company is now in default. It's not repaid a single cent. And all of the bank's security has disappeared somewhere in Kuwait. And we're now looking at what steps we can take to recover the money. There are all sorts of issues on choice of law and jurisdiction, contractual construction issues, and also a big question for the bank as to whether or not we might be able to bring personal claims against the officers of the company. So that's pretty interesting. As I say, I've been doing some quite detailed drafting on those cases over those 2 days. On Thursday, I was in court in relation to a freezing order for my client, who is a recruitment company. And about 2 weeks ago, they discovered that their head payroll administrator and their accounting man had been getting together and making up a whole load of fake employees, inserting their details into the payroll system and just paying themselves salaries of non-existent people. And over the course of about 5 years, they managed to steal over £4 million. And so last week, week before last, we went and got a freezing order against the main culprits. And I was in court on Thursday dealing with the return date on that. And then yesterday, I was in Con for most of the afternoon with a new client who runs a group of care homes. And they've got a problem because one of their managing directors left last year, and in breach of his restrictive covenants, he's now set up in competition with us, taken a whole load of our staff, a whole load of our old ladies from one of the homes, and they're basically damaging our business by their current operations. So that's a sort of a week in the life of me, if you like. Top reason number 2 is that you meet some genuinely interesting, dynamic, fun people. And that applies both to your clients. My clients have included oligarchs, the odd fraudster, given the work that I do, but also people, CEOs, big companies and banks, and they are usually pretty cool people to work with. But also you're instructing solicitors. If you do this kind of work, you'll usually be instructed by good city law firms, and you don't get to be a partner in a top city law firm unless you're pretty smart and you're pretty good with your clients. And usually they would like to sink the odd beer with you on a Friday night too. So you get to work in a really enjoyable environment. And top reason number 3 is that it's a reasonably secure and well-paid job. A lot of people, when they're considering whether or not to come to the bar or maybe take another avenue in the law, are worried about that. They think that the bar doesn't have good job security and or that it isn't well paid. But certainly on the commercial side, it's my view that it is both of those things. So those are the reasons to do it. The health warning, it can be phenomenally hard work, in 2 ways. One, because inevitably it's stressful. If you're dealing with millions of pounds of your client's money, and it may turn on decisions that you make, things that you do or fail to do, you will find it very pressurised. And there are nights when you will lie in bed all night in a cold sweat, worrying about what's going to happen the next day, and that's inevitable. If you haven't got the stomach for it, you shouldn't choose that particular line of work. And also there will be days when you have, maybe weeks, maybe months, a very intimate relationship with your desk. And again, you just have to accept that that's a fact of life. I was part of the junior counsel team on the Cherney and Deripaska case last year in the commercial court, which is, I think, the biggest case to go through the commercial court, very much like the Abramovich litigation. And we had 457 lever arch files that comprised the trial bundles for that case. I mean, it's absolutely huge. And I did spend about 6 months chained to my desk. That said, it comes to an end, all litigation comes to an end, and you're a barrister. You've got no one telling you you've only got 20 days leave this year. You can say to your clerks, that's it, I'm exhausted and I'm off. And go and lie on a beach for 4 weeks in the Maldives if that's what you want to do. And I think as that's one of the greatest selling points of the bar, is that you have genuine freedom of choice and control over your working life. There we are.
Excellent, thank you very much.
Dealing with the bar and why the bar. Well, firstly, the independence it gives you. It was touched upon earlier that you can, after a case, fly off to the Maldives if you want to. The great thing actually I find about the bar is that on a day-to-day basis, you're the one that dictates how much you work, the hours that you work, and the harder you work in this area of law, the more likely it is that you're going to succeed. And so that independence is absolutely crucial to your success, not only at the bar, but also in your chosen area within the law itself. The second reason I chose the bar was the chance to run my own cases. In my set at Henderson Chambers, we encourage the junior end to do various common law disputes at right at the outset of their careers. So you'll find yourself as a junior tenant working in various different commercial disputes, but they are not wholly focused upon the law of commerce. You'll find yourself doing employment law, product liability law, health and safety law, and that variety gives you a great edge. It's thought within chambers to those in other sets. The third reason that we say, or that I chose the bar, was the oral and the written advocacy involved at the bar. The bar has, to a certain extent, changed over the last 10 years that I've been practicing. There is now a great deal of litigation that is front-loaded, and much of it is won and lost on one's paper applications and the paper tactics that you adopt in any case. And for those of you who are strong on paper, the law, and in particular commercial law, is an area of practice that I think you probably would succeed in. The oral advocacy in the commercial world is of course critical, but to a certain extent it's less significant than those areas like, for example, criminal law, where it's highly likely that your advocacy skills are going to be put to their test from a very early stage and indeed throughout your career. Why commercial law? Well, three reasons again. Firstly, it's intellectually demanding. What I absolutely adore about commercial law is that it is fast changing. Now, to a certain extent, any area of law is fast changing, but commercial law, just by looking in the most recent law reports, you'll see is being dealt with not only at High Court level, but at appellate level. And therefore you are having an opportunity not only of practicing at that level, but also of researching in that area. And therefore the challenge of commercial law is one that I think is a very good reason for choosing commercial law. The second reason is that it's extremely various. There are, and my practice extends to insurance and reinsurance disputes and to full-blown bank-to-bank disputes. And whilst I accept that across all practice areas there is a degree of variety, the area of commercial law infiltrates various different areas of life. So, for example, you may get a small commercial dispute between the small and medium enterprises, but of course you're going to equally get those large bank-to-bank disputes that generate a huge amount of court work. The third reason why I chose commercial law was that it is a specialised area. So in my particular practice, which tends to focus on banking and finance, is is obviously absolutely critical when determining whether or not a bank is going to succeed in its claim against a consumer or indeed against another bank. And those sorts of disputes are always disputes that I've found interesting. What sort of cases do I deal with? Well, as I've said, it tends to be banking and finance. I work in both the areas of retail banking, so a lot of the payment protection insurance cases are cases that I've dealt with not only at county court level but also at high court level, and I've also dealt with and deal with investment banking at a high policy level and indeed at the high court level. So those sorts of cases at the moment will tend to be interest rate swap cases that are being defended by the banks. A typical week in my diary might involve an application to strike out a claim brought by a consumer in a county court. It would include preparing a defence in a letter of claim case on behalf of either a bank or indeed on behalf of a business. Advising at policy level on a financial institution's approach to the interest rate swap debacle, and a conference on the issues arising out of the Financial Services and Markets Act, or indeed the Consumer Credit Act. They're all cases and matters that I might deal with within the course of a week, and therefore that will give you a flavour of the sort of variety of work that you would be expected to do at a common law commercial set like ours. Why I find commercial law particularly appealing, firstly for me, the focus on commercial law tends to be about whether there is a contract, what the terms of the contract are, and what the construction that a court might put on a contract is. Those sorts of questions are questions that are ones that I've always found appealing, and indeed the likelihood is that in any commercial case that you deal with, that you will deal with those sorts of matters. Essentially, any commercial case tends to be about business law. And for me, that tends to focus on bank to bank or bank to consumer. And I've always been fascinated by how the city operates. And now I have an opportunity of analysing the operations, the contracts that are entered into by various different banks on a retail basis and indeed on an investment basis. And all of those matters are matters that are likely to be issues that you would consider when joining a set that focuses particularly on banking and finance and indeed commercial law. There is, of course, always a demand for specialists in areas. Now, there is a sense within at the junior end that one should always specialise as soon as possible. Certainly the view that's taken by a set like mine is that the ideal candidates are those people that want to focus on an area but are happy turning their strengths to various different areas of the law. So you may all be entirely interested in commercial law, but you should be aware that the expectation at the junior end would be for you to turn your hand to various different areas of commercial law. And the strength, I think, of a set that focuses on business law in particular is that you're given an opportunity of working within the area of business law at a very early stage. In terms of the lifestyle implications that you might make when choosing commercial law, well, the hours are long, there's no doubt about that, but they're long whatever area of law that you practice in. The expectation is by your clients and indeed by the opposition and indeed by your leaders is that you work hard. And so your weekends regularly are simply not yours. But the great thrill of winning a case as a result of the industry that you've put into the case is one that can't be paralleled and is rewarded, not only on a payment basis, but in terms of success individually at the bar, by ultimately perhaps taking silk and by perhaps thereafter joining the bench. So what are finally the key skills and personal qualities that I think will make you a success at the bar? Enthusiasm and industry, absolutely critical. And I won't make any bones about this. Your enthusiasm really has to come through during the course of your interviews. Now, I regularly sit on the panel for pupillage, and you see, looking through the paper applications, the very great qualities that no doubt many of you have, the huge successes that you've obtained whilst you've been both at school and indeed at university, and indeed thereafter in various different other professions. But by the time you reach interview, you have to understand that you've passed through the gateway and you're on, at that stage, a level playing field. And your enthusiasm at interview is absolutely critical when answering the questions that are put to you during the course of that. The second key skill is your intellectual ability, which is taken at a given. And I suspect at any commercial set, the expectation is that you would have obtained a first-class degree. Many of the applicants that apply to us not only have first-class degrees at undergraduate level, but have gone on to obtain distinctions at master's level and indeed have gone on to do doctorates and been very accomplished academics. So it's utterly critical that you commit yourself whilst you're at university to obtaining a first-class degree. The third skill that is critical in succeeding in commercial law is your commercial approach, knowing your client and knowing the issues that your client has to grapple with. Many an occasion when I'm being led by my head of chambers, he picks up the phone and speaks directly to the decision makers in the companies that he represents, not knowing the political circumstances of a company and the decisions that they have to make, and not knowing the decision makers in a company will hamper your advice given to a company. And it's really those three reasons that will, in my view, make you outstanding candidates at the commercial bar. Okay. What's your name? Nazeer, Chowdhury.
Well, I'm afraid I have to start with a few apologies. I thought that this talk started at 1:30. Clearly it doesn't, but if there is a lesson there, it's always check the listing before you go to court. So I think that's something that we all live in fear of turning up at the Wilson County Court at 2 o'clock and finding out that actually your possession hearing was listed for 10:30 and it's been dealt with in your absence. And then you have to make a rather embarrassed phone call to your solicitors. Now, fortunately, that's never happened to me, but today I'm very sorry that I'm late and it's my own fault. Secondly, I'm afraid I'm going to address you sitting down. I've a slight sprain, so if you can't see me, at least I hope you can hear me. You've had a very detailed talk there, and I dissent to everything that's just been said. And you'll see that I'm by no means as senior or as successful as my friend, so I'd certainly tell you to heed his advice. But perhaps what I can do is give you a view from someone who is very junior in practice and who has been in the position that you find yourselves in quite recently. So just to introduce myself, I'm Michael Ryan. I'm from 4 New Square. I'm one of the most junior tenants. I was taken on in October of last year, so this is basically my first full year in practice. As I said, that makes me a very junior. So I thought I'd just start off by sort of running down sort of what I do and what the average week or month might hold for me. I suppose the first thing to say is that it can be particularly unpredictable at the junior end. I suppose once you get more senior and you do ever bigger cases, then you can plan your time further in advance, as you know that you're going to be in the Court of Appeal for a week in 2014, whenever, or you're going to have a 2-month trial at some point in the future. But as a junior, instructions will very often come in at short notice, sometimes to attend a hearing in a couple of days' time, or to draft a pleading which needs to be filed by the end of the week, or even shorter notice than that. I remember being briefed for a trial in 2 days' time recently, which was quite a hairy experience, but we got through it. So that adds an element of, well, stress, I suppose, but also excitement about it. So just to give you a flavour of what I've been doing recently, on Wednesday I found myself in the Watford County Court resisting an application to set aside a possession order over some commercial property. So that really is sort of a typical application that you might be asked to do as a junior tenant in commercial practice. You'll get your instructions, there'll be an application notice from the other side, usually full of errors, and you might get some evidence if you're lucky. Usually in commercial chambers you find yourself acting for the bank or whoever it is who's trying to enforce their security. And then it's up to you really to run the case, as your solicitors will have an idea of what's going on. They'll have dealt with it up to this point, but then they will be looking to you to tell them what the position is as regards the law and what their prospects are and how they should present, or how you in court should present that application and what you need to do that. So that will so in this case, I told my solicitors I needed a witness statement which dealt with the various aspects that we needed to show in order to succeed in the application. They drew that up and they sent it to me. I did a bit of rejigging of the wording. So there's all that preparation beforehand in terms of the documents that have to be filed with the court. And then you have to draft your skeleton arguments, your written submissions to the court, which, as has been said, are extremely important. And then it's a matter of turning up and making your oral submissions. Now, in this case, just to prove how important written advocacy is, I turned up, the judge had read my skeleton argument, asked my opponent what his case was, didn't call on me to make any oral submissions, and gave judgment in my favour. Now, I think that's probably more to do with the fact that the other side were completely banged to rights than any great advocacy on my part, but it does go to show that just having things set out clearly and in a persuasive fashion on paper really can make all the difference once you get into court. So as I say, that's sort of a typical small application in the county court which you might be asked to do. Work for banks in relation to mortgage businesses is typical of that. But just as a contrast, for something in the same area but of a completely different kind, also this week I'm being led on a case which also has to do with a bank enforcing security over some property. But rather than being a rather small dispute in the county court, this is a major dispute in the High Court for several £1 million with allegations of negligence against solicitors and surveyors, and raising some quite intricate points of real property. And so, thank goodness, they've got a very good Chancery Silk involved, and I just do as he says. But that's sort of the other end of the spectrum of the kind of work that you might be involved in as a junior. And those big cases are an excellent opportunity to get involved in some very interesting and high-profile and high-value litigation, and a great chance to learn from people that have been doing this for a long time. And the other aspect, which I suppose is becoming increasingly important in the commercial bar is the international element of work, which is also something I've been doing this week. I'm also being led on something else, which is essentially a dispute about some dodgy goods. Someone sold some goods to someone else, and it's alleged that they're faulty. Now, that's something that you could easily be instructed to do on your own in the county court for someone selling goods for a couple of £1,000s and someone saying they're not up to scratch. But in this case, it's a contract which provides for sale of goods internationally and for quite a high value. So you're sort of dealing with similar points of principle and law, but in a very different context. And so that variety of work, I think, is what makes commercial practice so interesting. And you get it right from the off. As I say, I'm only my first year of practice, but these are the kind of things which can be thrown your way. In terms of that sort of balance between being on your own and being led, I suppose it varies from from chambers to chambers and from an individual's practice to individual practice. I suppose that most of my work is on my own at the moment, but increasingly I find myself being led, at this stage only by silks in my chambers. And I hope that's something that will continue. As I say, it's very interesting. In terms of the balance between being in court and being on my feet, then even at this early stage, the vast majority of my work is paperwork in chambers. As pupils in our chambers, we send our pupils out to court, which I know not all commercial chambers do, but we do, and so I suppose I've been on my feet since the beginning of, so it's about a year now I've been on my feet. And I suppose over that time, I suppose on average, and it's a rough average, probably about once a week I go to court. Now sometimes I might find myself in court 3 times a week, and then a couple of weeks might go by and I won't be in court. So it's certainly fair to say that if you're looking for a practice where you're going to be in court every day, then the commercial bar is not for you, as that's the nature of the beast. Personally, that suits me very well. I think I get to court enough to sort of make sure I'm developing my oral advocacy skills, and I do enjoy being in court. But the part of the job which really appeals to me, in addition to the oral advocacy, is that looking at papers and figuring out knotty factual and legal issues, which I spend a lot of my time doing, and which I enjoy. But that's certainly something to bear in mind if you're still thinking about what area of law do I want to practice in. In terms of why I went to the bar, actually I was thinking about this in advance of this talk, and I read law as an undergraduate, and I was trying to think back as to why I decided to do that. And I have to say, I think it was probably something to do with watching Kavanagh QC on telly and thinking, well, that looks like fun. I'm afraid the analysis probably didn't go much further than that. But anyway, fortunately, I went and read law, and I found myself enjoying it. And I particularly enjoyed the private law subjects, so contract, tort, trusts, land, property. And it was as I said before, the combination of interesting factual disputes and knotty legal, logical problems to be solved, which I found appealing about those areas of law. And I thought I'd like to be involved in that process, as was said, of that fast development of the law which goes on in the commercial sphere. And fortunately, I find myself doing that now. You are, as a barrister, you are at the cutting edge of the law, because of course, particularly as a junior being led, if something is going to court, then the reason usually is, well, there will be disputes on the facts, obviously, but very frequently there will be disagreements as to what the law actually is, and puzzling that out and fighting it out in court is challenging and enjoyable. In terms of the lifestyle, then it's absolutely true that you are expected to work very, very hard. I have a trial coming up where I'm being led in the TCC, which will be for 3 weeks, and will be up in Manchester for 3 weeks. And I should imagine that nearly every waking moment of those 3 weeks, and probably in my sleep as well, will be spent on that case. And it's going to be hard work, but it's going to be fun as well, being involved in a big, hard-fought dispute. So yes, it's interesting, enjoyable and rewarding, but be under no illusions as to how hard you have to work. What we're looking for in chambers for when people apply to us, yes, a strong academic record is a prerequisite, I'd say. Because in commercial practice you are thrown difficult legal problems on a regular basis, and being able to deal with those not only correctly and properly, but also quickly, as things happen very fast, is essential. And it's certainly true that both in my chambers and across the commercial bar, there are lots of people with frighteningly good academic records, strings of firsts and masters and doctorates and what have you. But I would say don't be dispirited if you don't find yourself in that company. I mean, I'm certainly not. So I would say that, whereas of course having a first won't hurt you, it's certainly not going to get you the job. And I would say not having a first is not a bar to getting into commercial practice. I'm quite aware that sometimes the distinction between a good upper second and a first-class degree can turn on a bit of luck on the day in the exams, maybe. But so I would say don't be dispirited if you're not sort of in the Jonathan Sumption League of academics. And so just a good solid record is what we're looking for. And we have people applying to us who have amazingly starry academic CVs, but maybe for some reason we don't feel that they're suited to our field of work or life in our chambers or whatever. So yes, I mean, work hard at the academics obviously, but not being the very top is not necessarily a bar. And then I would agree with everything else that's been said. Enthusiasm and a commercial approach is something we're looking for. And just that ability to communicate with people in a persuasive fashion, but also to get on with them. I mean, frequently in commercial practice, you find yourself in a very sort of hard-fought, almost gutter fight. You know, that does happen. But often it's not just the standing up and thumping the table and having those great oratorical moments, but also the ability to empathise with the judge, with the witness, to bring someone round to your point of view. And any way that you can communicate that in an interview is of course very important. And anything interesting that you've done. We get people coming to us at all stages and who've done all manner of different things, and very frequently sort of experience in some area of work may more than outweigh sort of starry academic qualifications. So anything interesting that you've done, flag it up on your CV, as it can often sort of mark you out. And so, as I said, I'm very close to the point at which you now find yourselves in, and I have a great deal of sympathy because I know it's very difficult and I know it's a long old slog. But if you really are interested in life at the commercial bar, then do as many million pupillages as you can, find out about it. I wish you the best of luck because it's a great job and I really enjoy it. And so good luck to you all.